My name is Janelle Elrod. I'm an attorney with Merritt, Webb in Durham, and I'm going to be talking about equitable distribution in family law cases. Equitable distribution is a claim where a 50-50 split of marital property would not be fair, so the court will determine what would be fair and split it evenly. This could occur if there is or is not granted alimony, and several different factors that the court will look at to determine if a 50-50 split would not be fair. An equitable distribution is just a division of assets and debts accumulated during the marriage, and there's 4 steps in an equitable distribution claim. First is identifying the property, second is classifying property, third is valuing property, and the fourth is to distribute the property. First, you'll want to identify all assets and debts, whether they're marital or separate. I advise just to make a list of everything you can think of, assets and debts that have accumulated from the marriage until the date of separation and even after. Sometimes taking pictures of the home or vehicles can give you a better idea of what assets you do have, and also if during the separation one spouse is to take some assets, you'll have evidence that they do in fact exist. The assets and debts will include anything you can possibly think of at this point when you're just identifying the assets. They can be memberships in clubs, bank accounts, any property that you have, personal property, real property. After you identify the property, then you'll go through and classify all the property, and it can be classified as marital, separate, divisible, or mixed. Marital property is any assets or debts that were obtained during the marriage, and this could be any deferred compensation plans, retirement benefits, things like that that may not be paid out until later. All of that will be considered marital property in the division of property. The second is separate property, which is property that has been brought into the marriage by one party, even if it changes forms. For instance, if a spouse comes into the marriage with separate funds, purchases a car or a home with those separate funds, that asset remains separate. Unless, and there's some exceptions to that, moving along with mixed property, which is separate property brought into the marriage, and now there becomes a marital element to it, and now the value of the home increases, or somehow those separate funds commingle into marital funds, and then that becomes mixed property. Fourth is divisible property, which is any property that's obtained after the date of separation. So anything that either spouse incurs as a debt or asset after that date of separation is divisible property. More examples of divisible property would be passive income that's accrued on any stocks or dividends that a spouse does not take any active participation in increasing or decreasing the value. That's going to remain marital property. After classification of the property, you'll want to value it, and you'd give that a fair market value as of the date of separation, or on bank accounts and credit cards. Whatever the balance was on the date of separation is what you value it at. And then finally, the distribution of assets, which again could either be 50-50 split, or in an equitable distribution case, when the judge feels as though a 50-50 split would be inequitable, they will again determine that equitable distribution needs to take place and go through these 4 steps in determining the distribution. Especially if there's a lot of assets that can't be liquidated, there's businesses involved where it's just impossible to split property 50-50.